How early should someone start considering legal documents like powers of attorney or advance directives?
Welcome to Barry's Bites. Please join our host, attorney and financial advisor Chris Barry.
Really, the question is when do we start thinking about estate planning? So understand, once someone turns 18, legally they're adults. And so that's kind of the starting point. For a lot of our clients who have adult age kids who are over the age of 18, at the very least, we're getting financial and medical powers of attorney put together, naming the parents to be able to serve that role. Because understand, once someone turns 18, even if you're paying for their insurance, legally they're adults. And so if they're injured, they're in a car accident, unless they have a medical power of attorney or HIPAA release, you wouldn't be able to talk to the doctors or anything. So I would say estate planning really starts at age 18. Once someone turns 18, at the very least, they should have a financial medical power of attorney, maybe naming a parent to be able to make those decisions. Kind of the next step in terms of looking at that life journey would be having a child. So getting married and having a child. Then we start looking at a will and a trust. The will would appoint a guardian. So God forbid something happens to you as a parent, who's going to serve as that substitute parent. And then with the trust, who's going to manage the money for the benefit of the kids. That would be really one of the first big life events, is getting married and having a child. And then probably the next big change in terms of that life journey would be, okay, now the kids are older, they're getting married, the kids are having kids, you're getting around retirement age. And so now a lot of times, a lot of our clients switch from just a basic trust plan that says it just goes out right to the kids once they reach a certain age. But now they're building in what we call legacy provisions. So now whatever the kids inherit from you would be protected from things like divorces, creditors, bankruptcies. And if they were to pass away, the money doesn't go to a spouse who might remarry, but stays in the bloodline. So it would flow down to your grandkids. And then if there aren't any grandkids, would go to the surviving child. So usually that's when clients get more near retirement age and they see who the kids are marrying. Not to say that we don't like the in-laws, but we jokingly call them the outlaws. So we want to keep the money in the family. So that's where maybe we upgrade from just a basic trust plan to what we call a legacy plan to protect that legacy. And then as we continue to age, a lot of times my clients see what's going on with their parents and the long-term care costs. And now they want to protect themselves from that nursing home or Medicaid spend down, which might be $10,000 to $15,000 a month. And so we upgrade from a legacy plan to an asset protection plan to protect against that nursing home or Medicaid spend down. I'd say there's kind of 4 stages. So the first stage is once someone turns 18, they need to have powers of attorney in place. At least naming the parents to be able to make decisions. God forbid there's an accident or injury or something like that. Because again, once someone turns 18, legally they're adults. So that would be the first step. And then the second step would be, now we're getting married, we're having kids, we want to put together at least a base trust plan. And then 20, 30, 40 years go on. Now we're getting near retirement age. We're seeing who the kids are marrying. The kids are having kids of their own. And now we're looking at a legacy plan. And then typically around 60 to 70, then we start getting concerned about long-term care costs. And we're looking at putting together an asset protection plan. Again, estate plan, it's not a one and done type thing. The estate plan is something that should be changing based on where we are in terms of the life journey. So hopefully that's helpful.